What is a DUI in Indiana? Well, first thing first, in Indiana, DUI is actually OVWI, but they're all the same thing. OUI, OWI, DUI, they're all the same thing in Indiana, OVWI. I call it DUI because that's what everyone else calls it, but technically the term is OVWI. Every week, though, somebody calls me, Mark, I've not been charged with the OVWI. I've been charged with the DUI. I promise you, it's all the same in Indiana. It's called OVWI. What does that stand for? Operating a vehicle while intoxicated. That's what it stands for. And that's what Indiana calls it. I promise you, you gotta trust me on that. So there's 4 elements. Operating. Sometimes this is clear cut. Officer saw somebody drive. Sometimes it's not so clear cut. There's a crashed car and there's someone walking away, or someone's asleep in a parking spot. Oh man, I love those cases. You know, operating is not as easy as some people would think, but basically you have to be in control of the vehicle. So there's always a chance to kind of scope that out, especially when there's not a clear-cut case of someone being observed by the officer driving. Now, the second element is a vehicle. That's pretty easy. Anything's a vehicle. Bicycle's a vehicle. Motorized coolers are a vehicle. Golf carts are vehicles. Obviously, cars are vehicles. If a person can be transported on it, it's a vehicle. There are some wacky cases we've done. Someone's passed out drunk behind a car that can't operate. It's not a vehicle. So there is some wiggle room with that, but vehicle is pretty easy. Now, the third element is while. A lot of attorneys take this for granted. No, well, operating vehicle while intoxicated, but while is actually a pretty important element. Operation has to be contemporaneous with intoxication. So it's not enough to show that somebody is drunk now and they might have operated the vehicle at some point earlier in the day. You have to show the combining of operation and intoxication. Now, Indiana gives law enforcement a little cheat, and they say, well, if you get the breath test within 3 hours of operation, we can assume that they were intoxicated at the time they were operating. Well, it's a 3-hour window and it's rebuttable, meaning you get to disprove it. So don't think just a DUI charge, oh, I can't beat it, there's no way. While can be a tricky element for the state to prove, especially if a person is not found behind the wheel or observed driving by a police officer. Now, intoxicated. Well, Indiana actually defines intoxication, and Indiana defines intoxication as alcohol, a controlled substance, any combination of alcohol, controlled substance, so that there's an impaired condition of thought and action and the normal loss of control of a person's faculties. So that's when you see people can't walk in a straight line or doing the field sobriety test, which no one should ever do, but they're going to try to use the field sobriety test to show that they're intoxicated. Intoxication, also encompasses the blood alcohol content number. We always hear 0.08, 0.15. And so if those numbers are present in a case, the state is allowed to use those against you, and it's called prima facie evidence of intoxication. But basically, if you blow 0.08, the trier of fact, whether it's a judge or a jury, can say, well, they probably were intoxicated, because that's the level of intoxication we kind of established in the state, which is really established by the federal government. So that's what a DUI is in Indiana. If you have any questions, give me a call. I love talking about DUI defense. I'll actually talk your ear off all day on it. And most importantly, remember, always plead the fifth.